All right. So welcome to another Blue to Gold webinar. I'm Zach Miller tonight. We're going to be talking about the community caretaking doctrine and the different areas in which we can apply a police officer's non-criminal investigative functions and capacities in a search and seizure context. A couple of things, as always, this is legal training, not legal advice. So first of all, make sure that your state law is not more restrictive. We're talking about the federal standard today. And when it comes to community caretaking, there isn't a whole lot of deviation state law wise, but check your state law, check your SOPs, because obviously policies can be more restrictive than any legal standard. A policy can't be more permissive, but it certainly can be more restrictive. Any questions that you're not sure of, make sure you push that up the chain and get an answer from someone in a position of authority. And again, legal training today, not legal advice. You get your legal advice professionally from your prosecutors, your city, county attorneys. If you're a larger agency, you might have in-house counsel. So those are the folks you go to for your um, legal advice. So here's what we're going to talk about today. We're going to talk about the basics, kind of talk about what is community caretaking, where does it come from, and then we're going to talk about how it's applied in different areas, pedestrians, stopping people who may need some assistance. We'll talk about vehicles, particularly stopping or searching vehicles for weapons and other kinds of dangerous items, stopping vehicles when we believe maybe there's somebody inside who might need some assistance. We're going to talk about inventories, particularly vehicle inventory searches. There's kind of an offshoot of the community caretaking doctrine. Inventories are kind of a hybrid between administrative searches and community caretaking searches. We'll talk about homes. How does the community caretaking doctrine apply to home entry? That's going to be a real short discussion. And we'll get to that one, and then we'll kind of wrap it up and summarize everything that we talked about today. So let's see. Yeah, right, Sean. It's when it comes to home, it's pretty simple. It doesn't apply. The Supreme Court answered that question a few years ago. We'll make sure everybody got that memo when we get to it. So the basics. Where does it come from? What is community caretaking? Now, remember, at Blue to Gold, we have our CREW acronym. And we're going to be talking about today one of the recognized exceptions. All searches and seizures require CREW. And what I love about this rule is, unlike pretty much every other legal rule we rely on, there are no exceptions to this rule. All searches and seizures, every single one of them, you have to have one of these three things. You either must get valid consent from someone who has authority, or at least apparent authority, to grant it, or you need a warrant, arrest warrant, or search warrant, depending on what type of search or seizure we're talking about. Or if you don't have either of those, the only other option is a recognized exception to the search warrant requirement. And there's many of them. There's, when it comes to cars, there's lots of them that apply to cars, the Carroll doctrine, or the automobile exception, whatever term you use. There's the search incident to arrest. That's a pretty broad exception. There is protective searches, like a Terry frisk, a vehicle frisk. Those fall under protective searches. And the one we're going to talk about today, community caretaking endeavor, searches and seizures under the community caretaker recognized exception. So today is all about one of the recognized exceptions to our CREW acronym. So community caretaking acts, what are they? These are really, is at its most basic level, they're just non-investigatory police intrusions into someone's liberty or privacy. So we're going to be talking about detaining people, searching people and their property for a non-criminal investigative purpose. We're not looking for evidence of a crime or contraband. We're searching for things that maybe present some kind of threat to someone, or we're rendering aid to someone who maybe is in need. We're trying to help, not convict. Is a good oversimplified way of thinking about it. Helping people, not convicting them of crimes. Now, of course, along the way, what starts out as a community caretaking interaction could easily quickly turn into a criminal investigation, depending on what we find along the way. Um, this is I love this quote here from the First Circuit. It's just kind of talking about police officers are just kind of expected to be society's jacks of all trades. Yes, one of our primary duties is to investigate crime and prevent crime, but we're also, expected to aid people who are in fight or combat actual hazards, prevent hazards, provide all kinds of services to people. When in doubt, you're having some kind of dilemma or problem. When in doubt, you call the police. Social worker, guidance counselor, parent. We're expected to assume all of these different roles in society besides that of just law enforcer. So community caretaker, babysitter, yes, right, Shane, babysitter in many regards. So we're expected, to do things other than just what we think of as traditional police work, and that gives us certain authority to do searches and seizures in some regard. Now, the Supreme Court's first case that really dove into this notion of community caretaking is Cady versus Dombrowski. A really interesting case as far as facts go. The case of the killer cop. Real quickly, here I've got some of the facts laid out here for you. Late 1960s, we've got Chester Dombrowski. He's an off-duty Chicago police officer. He's traveling in Wisconsin in his red Ford Thunderbird, and he runs off the road. He's intoxicated. His brother lives up in Wisconsin, so he's there visiting his brother. But he crashes his car. He is subsequently arrested for DUI, and the police tow his car and to just a typical private tow lot in a nearby town. 2 hours after he's arrested, he's taken to the hospital because he's been injured in the crash as well. But he's 2 hours later, he's at the hospital. He's under arrest. One of the officers, Officer Weiss, then goes back to the tow lot where Dombrowski's car was located. Officer Weiss, he believed that Chicago police officers were required to carry their service revolvers when they were off duty. His agency did have that policy, and he just presumed that Chicago had it as well. They knew he was an officer because they found his wallet, and he had his police ID. So, but he didn't have his gun on him. So he goes back to the car to look for the gun, and he doesn't have a warrant, and he doesn't have consent from Dombrowski. And he searches the car, and he gets to the trunk. He still hasn't found the gun, so he gets to the trunk. He opens the trunk, and he finds several blood-covered items located in the trunk. Later on, a few days later, a homicide has been discovered on a farm, which actually belonged to Dombrowski's brother. They found a body that was linked to the blood and other items that were found inside Dombrowski's car. So obviously, Dombrowski, he's ultimately arrested and charged with murder, and he's moving to suppress the bloody evidence that's found in his car because he said Officer Weiss had no justification for searching his car. Where's your warrant? I didn't give consent. There's no kind of emergency. And the Supreme Court says he's charged with first-degree murder. The Supreme Court answers this question: was the warrantless search of his car lawful? And the answer is yes. The court talks about how local police officers are unlike federal officers, and most of the vehicle search cases the Supreme Court had dealt with before Dombrowski, most of them involved federal agents searching cars for contraband and evidence, things like Carroll versus United States. But the court says, local officers are a lot different than federal officers. Besides looking for evidence of criminal activity, when local officers encounter vehicles, it's many times for criminal purposes, like investigating traffic crashes or helping stranded motorists and things like that. So the rules for searching cars may be different for local police officers than state officers. And the court said this type of caretaking search that Officer Weiss conducted was lawful. We have a car that has been towed to a private tow company. It's an unsecured lot. There's no guard and there's no fence around the property. And here's the police believing there could be a firearm located in this vehicle because of who was driving the vehicle. So in the interest of public safety, making sure we don't have a firearm in an unsecured vehicle, the court said it was reasonable for the officer to go and search the car. And of course, he happened to discover along the way in plain view evidence of criminal activity. So this was the first time the court upheld a warrantless search for something other than criminal investigative purposes. So this is our first uh, diving into of the community caretaking exception by the Supreme Court. All right, so let's talk now about how the courts have applied community caretaking searches to different categories. We said we'll start with talking about people. Can you detain someone under community caretaking authority? Can I walk up to someone and seize that person, restrain their liberty for a period of time for a non-criminal investigative purpose? And the answer is yes. We can stop a person when we have a reason to believe that this person is in apparent peril, distress, or is in need of some kind of aid. So obviously, this is going to be predicated on our ability to articulate this kind of concern that we have about this person. So most states seem to subscribe to a kind of a three-part or three-step rule or test when it applies to community caretaking stops of people. The first requirement is for the basis for the stop. There has to be an objective, fact-based, articulable fact-based reason for detaining this person. So, and this is viewed through the eyes of an experienced police officer, a reasonably well-trained police officer. He or she sees someone who apparently needs some kind of assistance, and as long as that basis can be articulated and it's reasonable, then that's the justification we need. We'll talk about whether that's reasonable suspicion or probable cause here in just a second. But we've got to have an articulable basis. Putting it into words for believing this person needs help. And then once we have that sufficient belief, then the officer can take an appropriate action to assist that person or mitigate this peril we believe they're in. And of course, the means we employ have to be reasonably designed to address this concern. Okay, so there has to be a sufficient nexus between what we're doing and the likelihood of it rendering the assistance we're allegedly engaging in. So we can detain this person and provide this needed assistance or whatever it is we're trying to do. Then the third part of the rule is once we have addressed the issue, we've rendered the aid, we've mitigated the peril, we've determined this person doesn't need any assistance, then our authority to detain that person is over. It has to cease immediately unless we have developed reasonable suspicion, at least, of criminal activity. But any further detention, once this threat or this concern has been addressed, any further detention is going to be, it's going to be considered a separate detention for Fourth Amendment purposes, and the typical rules apply. You need reasonable suspicion, at least, or consent. And so this is just a Montana case, but it lays out the three steps or the three requirements, and most states seem to subscribe to this typical rule here. All right, so a community caretaking stop, it's really just a Terry stop for non-criminal investigative purposes. So what that means is all of the rules that we would think that apply to Terry stops, they're going to apply to our community caretaking stops. So when it comes to detaining a person under the community caretaking authority, it's basically a Terry stop just for non-criminal investigative purposes. So what are the things that we know that go into a Terry stop? Well, first of all, you need to have reasonable suspicion. So that's the standard we're held to. I've got to have reasonable suspicion that this person is in need of some kind of assistance, or there's some kind of threat to this person. There are temporal, which means time, and scope limitations. Remember, Terry stops, what are they supposed to be? Brief. Terry stops, as far as their duration, they're generally measured in minutes, not hours. We're not allowed to keep this person detained for long periods of time with this reasonable suspicion we have. And then what do we mean by scope? Is what we're doing during the Terry stop, or the community caretaking stop, has to be reasonably tied to what it is we're trying to investigate, or what kind of aid we're trying to render. If I'm detaining this person because I believe they need some kind of medical assistance, asking them a whole bunch of questions about um, criminal conduct generally isn't related to the medical emergency that might be experiencing. So that's what we mean by scope. The questioning, the things we're doing have to be reasonably related to this concern. And then further intrusions upon their liberty, things like handcuffing them, which, Terry stops, we are allowed to handcuff people on Terry stops. But handcuffing generally is the exception, not the rule when it comes to Terry stops. Whether it's a criminal Terry stop or a community caretaking Terry stop, doesn't matter. We have to have a reason, an articulable reason why this guy on this stop needs to be put in handcuffs. And we'll look at a couple of cases here in a few moments where the officer used handcuffs on a community caretaking stop. Let's see what the court had to say about that. Can you take someone into custody? In other words, make an arrest under community caretaking authority? Absolutely, you can. In fact, this is so all states have some form of involuntary mental health commitment process where you effectively arrest someone once we have a reason to believe they are some kind of threat to themselves, or usually it requires immediacy, but an immediate threat to themselves or someone else. Most states, actually, I would imagine all states, have some kind of process by which we can take that person into custody and get them the mental health treatment that they apparently need. Usually these are probable cause based types of arrests in the constitutional sense of the word. So state law is going to be very, very important here. But there could be other reasons. There could be other reasons besides mental health services that we could take somebody into custody. Let's look at first, protective custodies. Protective custody's got to comply with state law. Usually there's procedures that we have to follow when it comes to these mental health commitment processes. But let's look at this example here. It's not a mental health case, but here's we've got a gentleman. He's at a livestock show. I think this was in Wyoming was where this occurred. But he gets there. He doesn't have a pass or ticket to get in. He's not able to answer questions posed to him by the staff. He seems disoriented, and it's 6 degrees outside. So the staff contact the police, and the police take him into protective custody. They don't arrest him. He's not arrested for being drunk in public. He's taken into custody, and he's taken back to a police facility to basically sober up, and then he's released once he's able to care for himself. So and the court said, under the totality of the circumstances here, he was a danger to himself. If he were to be left in that condition, the 6 degrees outside, he doesn't seem to know where he is. He's clearly intoxicated. He's clearly a danger to himself. So the law enforcement interest in taking him into custody was reasonable under those circumstances. So, but how about let's compare it with this case. This is a case out of Massachusetts. It's at a concert. Here's what happens. We've got a gentleman. He shows up to the concert. He's out there tailgating in the parking lot. He admits he's had 6 to 8 beers over several hours. He goes to go into the concert. Security contacts him. They determine he's apparently intoxicated. So they send him off to the side, and they contact law enforcement who's there doing off-duty work. And an officer does some field sobriety tests, and he does he does okay on them. The court said he partially passes the test. Most of your DUI enforcers will say these aren't pass fail; these are just exercises. But he does okay on them. But he refuses to take a breath test. So the officer places him in what the officer calls protective custody, and takes him to the police station where he's held for about 5 hours until he sobers up, and then he's released. He's not charged criminally, so he's not arrested for being intoxicated in public. He is just taken into custody for his own protection. Very similar to the type of custody in the case we just talked about. So, what did the court say? So he sues. So he gets out. He sues. He says, "I've been illegally seized." The court says, just because you're intoxicated does not mean you are incapacitated necessarily. This guy, he was here with a couple of his friends as well. So the court said this protective custody arrest, if you will, was unlawful. And the officer was also denied qualified immunity because the court said it was a reasonably well-trained officer would have been already on notice that you can't do this. So two at least outwardly appearing similar cases with two different outcomes. The first case we talked about, had that cold weather. The guy didn't seem to know where he was, and he's intoxicated. This guy's just, had a little bit too much to drink with his buddies, and he's at a concert, and there didn't seem to be any other factors at play. So the court said no community caretaking for the officer here. Again, this is just a quote. There may have been facts that the officer just did not articulate well enough to show his genuine concern for this guy's safety. But since the officer did not articulate enough facts, the court said we don't see any legitimate community caretaking purpose present. Yep, Shane. If you don't articulate it well, I mean, it effectively didn't happen. If you don't, if it's not in your report, not articulated well in your report, that's the chances of you being able to after the fact remedy it is not very high. Here's another one. We've got someone calls the VA, and he says he's consumed a lot of alcohol. He's suicidal. He's having an adverse reaction to his meds. He's got guns, and apparently this particular person has a history of suicidal threats. Police take him into custody for mental health evaluation. This obviously is the quintessential example of a community caretaking protective custody. There's clearly on these facts, the officers have probable cause to believe he's a danger to himself or others. I mean, he admits, that he's got weapons, he's made prior threats, he's got the adverse reaction to medication, and also, this was the officers were at his house, and they're in there talking to him, and they apparently here in this, and I don't remember what state this was in. It's the Fourth Circuit, so I think it might have been North Carolina, but there's a process by which you're supposed to go get a commitment order issued by a judicial official, but the court here recognized there was also an exigency present. We can't leave this guy at his home while we run off and get this commitment order. So the warrantless seizure, the warrantless arrest, if you will, for community caretaking was justified here because of the emergency of the situation. So that's the perfect example of the community caretaking at play when it comes to a person who is in dire need of services. So this one's interesting. This is a case out of Maryland. We got a guy, officer on patrol, and he's driving down the road, and he sees a guy laying in the middle of the road, just laying in the middle of the road. So the officer gets out and then starts having a conversation with him. He can, I think he smells some alcohol on him. He's got some injuries on his face and knuckles. It's 5 a.m., so maybe he got into a fight. So the officer, He decides to handcuff the Mr. Wilson here. His intent is to take him to the hospital to seek medical treatment. Well, Mr. Wilson apparently did not want to go to the hospital and get medical assistance. He resisted, which leads to this physical struggle. So he's then charged with resisting arrest. And I think at some point, oh yeah, he's trying to dispose of some marijuana that he has in his pocket. So the issue here is, did the officer have the authority to take him into custody in the first place? And the court says not on these facts. They did not have any probable cause, or did not have probable cause to believe he was a danger to himself or others. Again, he's the, you know, if maybe you have a drunken public statute, or some kind of maybe disorderly conduct statute that may apply, but they're not arresting these people for criminal conduct. They're just according to the officer, taking him in to get medical treatment, and that requires some belief that he's a danger to himself or others. And the court points out a few things. Well, if you were so concerned that he needs medical treatment, why was an ambulance not called? Is one of the things the court asked about this particular situation. Why the need to drive him to the hospital in your patrol car instead of just waiting for the officer, or waiting for the medic. So again, the court says not enough to believe he needs, or that he's a danger to himself or others. Is he suspicious? Yeah, he was laying in the street, laying right in the middle of the road. So there probably are several different statutes under which he could have been arrested, but for whatever reason, the officer chose not to pursue those avenues. And um, unfortunately, it led to the suppression of the marijuana and the not guilty speed bump. They very easily could have been at 5 o'clock in the morning. Somebody who was not paying attention might have run over him. So that's people. All right. So that's detaining people. Yes, we can detain people if we've got reasonable suspicion to believe they need they're in peril, or they need immediate medical attention, or some kind of threat they're experiencing. What about vehicles? Let's talk about vehicles and community caretaking. Particularly searching vehicles for weapons. And we can search and seize firearms that are in a vehicle if you have some genuine and articulable belief that someone in the public could access that weapon. This usually involves, vehicles that are being left like in a parking lot or something like that after someone's been arrested. And under the community caretaking justification, this certainly could apply. This is what Cady versus Dombrowski was about. The Chicago officer and searching for his off-duty gun. That's kind of where community caretaking got its start. So here we've got Mr. Johnson here. He's placed under arrest, and he's got a car, and I believe it was being left. It was lawfully parked in a parking lot somewhere, and the police see a gun on the passenger seat. So they seize the gun, which they're permitted to do. They're not going to leave the gun in open view in public like that. They find ammo to a different firearm nearby, like where the revolver was on the passenger seat. They also find some ammo that doesn't apply, that doesn't fit that gun. So they look in the trunk, and there is evidence. I think there's some narcotics and other things inside the trunk. So the question is, was looking in the trunk justified? And the court says yes. It was reasonable on these facts to believe there could be another weapon in that vehicle. We've got one gun which was in plain view. No question, we can take that one. And then right next to it, or nearby, there's in plain view ammo of a different caliber. So it's reasonable to believe there could be another gun inside the car. So the court said this is an appropriate community caretaking type of a search. Again, just like in the case of Cady versus Dombrowski. There was also an inventory search. So this is when it comes to vehicles, a lot of times the community caretaking authority kind of bleeds into the inventory search process as well. We'll talk a little bit more about inventories in a second. So you have to have a community caretaking purpose to access the vehicle, and then the inventory is guided by these routine procedures the court's talking about here, which are usually your policy is what governs that. So here's another gun in a car case from out of the 10th Circuit. And here, again, driver's arrested. He tells the officer that he has a gun in the trunk of his car. And he would like to leave the car in the parking lot where it is, where the arrest occurred, and the owner of the property was fine with leaving it there, and it was lawfully parked. So that was the plan. But the officer, he retrieves the gun in the trunk, but then he decides to search the rest of the car, claiming he's looking for more weapons and ammo. And then he pulls the door panel off of one of the doors, or he peels it back, and he can see inside the door panel, or behind the door panel, is cocaine, a significant amount of cocaine. He says that he's looking for more firearms inside the door panel, and the court says this is not a legitimate community caretaking search, because in this case we've got the one. Remember Lugo, the guy that was arrested, he says, I have a gun in the trunk, and the officer recovers that, but there's no indication there could be another weapon inside the car, unlike the case we just talked about with the ammo that doesn't match the caliber of that firearm. So in this case, the court said this was not a legitimate community caretaking search. And also, they also tried to justify this as an inventory search, and the court was not having that either. When you start peeling the car apart, looking in crevices and void areas of the car, courts they take a very cautious look about that. We'll talk about some red flags here in a little bit that courts are on the lookout for when we're doing inventory searches. There's certain red flags courts look out for to see, is this really an inventory search? Are we looking for evidence in contraband? And this is a perfect example. When you start to dismantle the car, a good piece of advice I always give officers: if your inventory search involves using tools or dismantling the vehicle, it's probably gone beyond the scope of an inventory search. Even if your policy tells you could do that, courts are not going to give that a lot of credence. So this case, the cocaine that was found behind the door panel was ultimately suppressed. Yeah, if Dan says, if they had probable cause, would this have been a lawful search? Yes. So if we have probable cause, so under the Carroll doctrine, if we've got probable cause to believe there's contraband inside that car, we can search anywhere in that car that it's reasonable to believe what you're looking for could be found. And if we're talking about narcotics, that's anywhere in the car. But the officer did not have, or at least there were no facts in the record that suggested he had probable cause to believe there was contraband in the car. But yes, with PC, you can dismantle the car. You can pull panels off and look for, depending on what you're looking for. Obviously, narcotics and drug trafficking, those kinds of searches typically do lend themselves very well to those kinds of very, very thorough searches. Yeah, Sean says, I'm assuming, Sean, you're talking about inventory searches. Iowa, it's been several years now. The Iowa Supreme Court, yep, they said basically, if I remember correctly, an inventory search in Iowa today under state law involves you standing outside of the vehicle, looking inside, and noting anything you can see from the outside, and that's pretty much it. There's no more rummaging through the vehicle under state law, because and of course the name of the case, is it Ingram? I think it might be State versus Ingram is the name of the case. Yeah. The court, it's a long opinion. And they spent a lot of time talking about how over the years officers have been clearly exploiting inventory searches as a means to look for evidence of contraband, and basically they said we've had enough of it. We're gonna use our authority to decide that the state constitution does not allow inventory searches unless you have some reason to believe there's actually something of value inside that car. So yeah, inventory searches effectively don't exist in Iowa, and there's a few other states as well that take a restrictive approach to inventory searches. All right, so occupants. So stopping a car because we believe someone inside the car needs some assistance. And this should make perfect sense. If I can stop someone walking down the street and do a Terry stop if I think they need assistance, then it should stand to reason that I can also stop them if they happen to be in a vehicle. You don't have any greater, liberty protection just because you're inside of a car. So yes, we can briefly detain vehicle occupants if we believe someone inside needs assistance. And again, just like the stop of the person, we need reasonable suspicion to believe there is some kind of community caretaking purpose. So here's a couple of examples. This is in New Jersey. Officer is behind a car. This is late at night at a red light. The light turns red, and the car doesn't move. I'm sorry, the red light turns green, and the car does not move for about 5 seconds. And the officer pulls the car over after it starts to move after 5 seconds, and that was it. That was the only thing the officer articulated as a basis for the stop. There was no other traffic. It was only the officer was behind him, and the court said they talk about some prior cases in New Jersey where we have upheld community caretaking stops where there's some kind of abnormal vehicle operation that suggests someone might need some help. But here, that inference that this person needs some kind of assistance because he's sitting here for 5 seconds after a light is turned green is not sufficient. That's not reasonable suspicion. Yeah, there's lots of reasons. Common, Sean says there's common today with people at lights, playing with their phones, not paying attention to the light. So there's lots of non-emergency, non-medical, non-criminal reasons why people might be delayed in pulling off at a green light. And court said, you need more than that. You need more than he sat there for 5 seconds. Is it something that would draw your attention to the vehicle? Absolutely. As a police officer, absolutely. But standing alone, it's not going to be enough to stop the car, even if we are alleging it's to make sure they don't need assistance. We turned out to be a drunk driver. Imagine that. Mr. Cryan turned out to be intoxicated. Here is a car that was, quote, driving at a snail's pace, 5 to 10. So it's a 25-mile-an-hour residential area. It's late at night. I think it's like 4 in the morning. And the officer observes this car again, driving really slowly up and down the street, 5 and 10 miles an hour. And the court says that's definitely abnormal. And this kind of abnormal conduct suggests there could be some objectively reasonable reasons if you will, for believing something might be wrong with the car, something mechanically wrong with the car, or something wrong with the people inside of it. Or the court said this could potentially be a safety hazard for someone who's approaching this car from the rear, doesn't realize this person is driving 5 or 10 miles an hour because he doesn't have his flashers on. So his slow movement on the road could present a threat to somebody else. And the court said this was sufficient to justify a stop. And I believe Martinez also turned out to be intoxicated. So driving slowly at night, 5 to 10 miles per hour, far less than half the speed limit. The court said that was sufficient for the stop under the community caretaking exception. This was a disabled vehicle in Pennsylvania. A trooper, so a car is on the side of the road, so pulled off completely on the shoulder, and a trooper pulls up next to the car. So in the lane of travel, he pulls up next to the car and activates all of his emergency equipment. And turns out Livingston, she was also intoxicated, but the trooper, when asked, why did you do it that way? He said, that's what I do. I do it for every car. Every car that's disabled or pulled over on the side of the road, I always pull up next to them and see what's going on. And the court is saying we have no doubt the trooper was genuine in his intentions. He's just simply checking to see if they need assistance. But the problem here, so the problem, first of all, is the lights. So he pulls next to the car and he has all of his lights activated, not just his rear deck lights, but the whole front and back. And the court spent a lot of time in Livingston here talking about how a reasonable person would see, the flashing red and blue lights as a sign that you're not free to leave. So the court concluded when the trooper drove up next to him, or Miss Livingston, and activated his lights, he seized her. She would a reasonable person would believe they're not free to leave. And I think that's probably the appropriate way to decide that. So now that we know that it's a seizure, whether the trooper intended it to be a seizure or not is irrelevant. It is a seizure as a matter of law. So now it has to be justified. And the Commonwealth of Pennsylvania tried to justify it as community caretaking. The trooper is making sure this person doesn't need any assistance. But the problem, the court said, as you can see here, there's no evidence other than the fact the vehicle is pulled off on the side of the road that someone inside that vehicle needs assistance. They had not received like a call earlier, a stranded motorist call. There's nothing indicating the vehicle's having mechanical issues. It's just a car pulled off on the side of the road, and the court said this was not a legitimate stop uh, under the community caretaking authority. Well, what could so this first of all, this is a good reminder of, just because I always do it this way, or just because that's not a recognized exception to the warrant requirement. Why did you do that? Just because I always do, or just because we have to have a specific legally, judicially recognized exception. Now, what could the officer? No, 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 oh, I'm sorry. What could the trooper have done? The court is not saying you can't check on motorists parked on the side of the road. What could he have done in a situation instead of pulling up right next to him and turning his lights on? Just stop behind him. Stop behind the car and turn your rear lights on to obviously to warn oncoming traffic. Yeah, because case law says I can is also never a good response when asked. When and I always like to tell, particularly young officers, when we're especially recruit training, when let's say you're on the side of the road, you're searching a car, and your sergeant shows up and he walks up to you and he says, not in an accusatory tone, but just in the, as it's the sergeant's job to know what you're doing, and he just simply asks, hey, why are you searching the car? Just not accusatory, just doing what sergeants are supposed to do, which is supervise. And he says, why are you searching the car? Here is an answer. Here is a legally insufficient response. Because I can. I'm searching the car because I can. That very well may be true, but that's not the answer we're looking for. I'm searching the car, Sarge, because I have probable cause to believe there's narcotics in here based on these factors, and therefore, under the Carroll doctrine, I am searching the car without a warrant, or I'm searching the car because we have a tow truck on the way, and our department inventory policy says we're going to search the car. So yes, knowing why you can do what you are doing is always a critical thing in our profession. What we call it matters. If it's a community caretaking stop, we need to be able to articulate the basis for the rule that applies to community caretaking. Now, what could that true? So, like, going back to the trooper, what could he have done? He could have pulled up behind her, activated his rear lights, and then just walked up to her, Miss Livingston, on foot, and asked if there was anything that she needed. So it was kind of the way that he played it out. Now, compare it to this one. So this is another Pennsylvania case, and we've got here's what happened. We've got a guy in a car. It's late. Actually, I think there's a couple of people in the car. They look like they could be sleeping, or maybe they're passed out in this car. And one of the things, this is an 18-year veteran officer. One of the things he says is, I have found dead people in cars at different points in my career. We didn't know. This is actually what his testimony was. We didn't know if it was a medical situation. He could just be asleep, or if it's a DUI. And he's out. He candidly admits, I'm out looking for criminal activity, but I'm also there to help people out. And it turns out this guy, there was a bunch of drugs inside the car when they ended up waking him up, and the court was okay with it. Okay with this. The court said the officer articulated very well his reasonable basis for believing there could be someone who needs some attention in his car. He's got a guy. It's late at night. He's leaning back. He's motionless, apparently unconscious. This officer's 18 years of experience in that particular area. All of this made it reasonable to believe this is someone who could need some kind of emergency assistance. And the court said the detention was lawful. So articulation is key, and this is both of these last two cases illustrate this point. Don't assume the court is automatically gonna, if you just say community caretaking, I'm just doing it just to make sure someone doesn't need assistance. That could be a very noble reason, and that could be the true reason, but you still have to articulate your basis for believing those things to be true. Courts are not going to just automatically say, "Oh, well, officer, if you say you were there to render aid, then we're good with that." You still have to articulate your basis, because it's still a seizure. It's still a seizure of a person in a vehicle. Inventories. Inventory. So the inventory searches, there's several Supreme Courts cases that deal with this. Opperman is South Dakota versus Opperman is one of them. Opperman's car is being towed by the Vermilion Police Department in South Dakota because he's had a bunch of prior parking tickets, and now he is again violating parking ordinances. So they tow his vehicle, and pursuant to their agency policy, they do an inventory search. And I think they found some marijuana inside of his car. And I think most of you know the Supreme Court said this was lawful. The towing was serving a legitimate community caretaking purpose. So there's two components to an inventory search. We're going to cover them here in just a second. The first is the towing has to first be lawful. The towing has to serve some kind of community caretaking purpose. And then which is this is an unoccupied vehicle. It is parked in violation of a city ordinance, has a history of these violations. It's reasonable for the police to tow it, and there was the policy. We'll talk about that in just a second. But the court says this is clearly the police acting in their community caretaking authority. So the towing was lawful. And because the officer's agency had a policy to do the search was lawful as well. When inventory searches, we find contraband or evidence inside the car during an inventory search, and so now we have criminal charges, and these things end up going to court. They end up getting litigated. The issue that's litigated most frequently with inventory searches is the towing. Was the officer lawfully towing the vehicle? In other words, is there a community caretaking function that is being satisfied by towing the vehicle? And as we talked about with the Iowa case, and in many cases like it, inventory towing a car cannot be a pretext to allow us to search for evidence in contraband. And courts are, like I said, they're very much aware that police officers sometimes take shortcuts. The Supreme Court warned about it in a couple of their inventory cases, that if there's evidence that this towing is a pretext to do an investigative search, we're gonna potentially render the search unlawful, even if you're following your policy. If there's a suggestion that there's primarily an investigative motive. Now, you can have a dual motive, but as long as it primarily appears like your primary reason for towing it is because of some community caretaking purpose, courts tend to discount the investigative, ulterior motive, as long as it's primarily reasonable. And we'll talk about things that courts look for in just a second. But here's the two things to make an inventory search lawful. You first have to have a lawful towing, and then the agency that's doing the search has to be adhering to the standardized procedures. We would normally call it a policy. The reason the policy is required for an inventory search, according to the Supreme Court, is because the court doesn't want the officer in the field who's doing the search to have a lot of discretion about how to do the search, where to look, how to document it. They want all of the decision making as far as how to conduct the search to be made ahead of time by administrators, so that when the officer comes to doing an inventory search, all he's doing is following the rules. Here's the policy. I'm just following step by step through the rules. That doesn't eliminate, but it significantly mitigates the threat of a pretextual inventory search. So again, I just reiterated it here. Two things that are required to do an inventory search: lawful police order tow, and then the officer's adhering to standardized criteria. Now, as far as the towing, so the only thing that you have to have a policy on is the search itself, the inventory search. If you don't have a policy or some kind of standardized criteria that your agency uses, it doesn't have to be a written policy, but in today's day and age, that is the easiest way to accomplish it. No policy or no criteria, no inventory search. You can tow a car, but you can't do an inventory search. But some of the lower courts also say the towing decision has to also be guided by a policy, and there's like I said, there's a split. So some you want to make sure you're check your state law on this one. Make sure your state, if it does require um, a policy on the decision to tow, you want to make sure you're adhering to that as well. The three reasons we're allowed to do inventory searches, I think most of you know this very well. One, we're protecting the owner's property. We got this vehicle, it's in our custody, and it's being usually towed to some private tow company's lot. So we want to, if they have anything valuable in there that we don't want them leaving it unsecured, we want to secure that for them. So we're protecting the owner's property. We're also protecting ourselves against claims of damage and loss. So if something turns up missing when the person returns to pick up their vehicle, whenever that is, they can't then come back and say we were responsible for whatever is missing because we cataloged everything that was in it when it was towed away. So anything that's missing happened after we released custody of it, and also to make sure there's nothing dangerous, guns or other dangerous items left in these vehicles, which are typically not left in the most secure areas. So if you're doing an inventory, if you're towing a car under community caretaking authority, which leads to an inventory search, we want to generally articulate one of these reasons here: the vehicle is illegally parked, therefore it needs to be towed, or it's blocking traffic, or it's some kind of hazard. It's in a dangerous area, it's in a place where theft or vandalism is likely. And also, policy or law might require the towing. Now, just because your policy says you shall tow cars doesn't necessarily mean that it's a constitutional policy. The policy should also address community caretaking purposes. Remember, policy cannot grant you more authority than the law does. And state law also mandates towing in some cases, a lot of DUI cases, particularly multiple offense DUIs. There's usually an administrative impoundment that goes along with the vehicle. So those could be all legitimate reasons for towing the car. Here's some of those red flags I mentioned. These are things that courts look out for. So if we're doing allegedly an inventory search of a car, courts are looking to see, is there any kind of community taking rationale that was articulated as the reason for towing in the first place? We do a thorough inventory search and then we call for the tow truck. Courts say sometimes that looks like you were looking for evidence, particularly if you do a thorough inventory search and you do find evidence or contraband, then you call a tow truck. That a court is likely to say that's not an inventory search. We're towing a car that we normally wouldn't tow in a situation like this, and then all of a sudden we're towing this particular car, so we needed to do an inventory, and oh, lo and behold, there was a large amount of narcotics in the trunk of this particular car. Court says, that looks more like an investigative type of a search. We are searching parts of the car that you wouldn't typically look at for an inventory search, like remember pulling the panel off the door, pulling the dashboard out and searching the ductwork behind the dashboard. Not areas you typically would be inventorying, and whether or not the officer is following the towing and inventory policy, or these are things courts look for. Let's see what we got here. Oh, hold on a second. Why are we? We got a little hiccup here. Let's try this. Let's skip through it. All right. What we have a towing here, Mr. This was a car that was parked on the side of the road. It had been sitting there for a couple of weeks, and there was at some point in this 2 weeks, officers started to think this car might be involved in a burglary that occurred in the neighborhood. And again, it just been sitting there for 2 weeks, so they invoked this rarely used city ordinance that allowed them to tow this abandoned vehicle, and they found evidence of the burglary inside the vehicle. And the court said This appears that the primary reason for towing this car was to look for evidence, not a community caretaking purpose. So again, they're looking at the reason for the tow we're towing it under this ordinance, but we don't normally tow for that. Court looked at that very suspiciously. Again, there was no exigency here. They didn't have probable cause to search the car on it either. So the court was very suspicious of it and said, not a legitimate tow, therefore not a legitimate inventory search. This is another case. Officer is towing a vehicle. But he said he said to it, there was a partner on scene. He says, I think there's something else going on inside this vehicle. This guy had a suspended license. It was legally parked at the time, and there was no legitimate community caretaking purpose that was articulated. And the court said this clearly is pretextual. There's lawfully parked. You've made this comment about you think there might be something else in the car. Then they call for the tow truck and they do a search and they found contraband in the car. The court says, no, this sounds more like a pretext. How about here's the question for you. If we want to search a vehicle for evidence or contraband, but we don't have PC or consent, but we do have discretion to tow this car, like our policy would allow us to tow this car, but we normally wouldn't do it if we didn't have this reason to believe there's evidence in the car. What should we do? So we don't have PC, we don't have consent. We could tow this car under our policy, but we normally wouldn't. Well, what should we do here? The answer is we shouldn't tow the car. The answer is you shouldn't tow the car. Some of them you just got to let it go. I love it, Shane. Love it. The weirdest shit meter is not a recognized exception. No, it's not. Well, believe it or not, it is not one of the recognized exceptions that satisfy our crew rule. So, if there's no legitimate reason to tow this car, then we don't tow this car.
Goodbye, my love. Bye.
Yep, sometimes you just need to say bye. We'll get it next time. Let's let it go. All right, homes. We're running up on the end here, and remember how I said this will be a short one. Home entry. All home entry requires one of these three things. You cannot enter a home unless you have consent, a warrant, or exigent circumstance. So as far as crew goes, the only recognized exception for home entry is exigency. Now there's a bunch of subcategories. There's hot pursuit. There's emergency aid. There is imminent destruction of evidence. So there are different types of exigency, but exigency is the only category. And a few years ago, in Caniglia, I think is how you pronounce it, or Caniglia, one of the two, the Supreme Court was asked to answer the question: can we enter homes under the community caretaking doctrine to render to perform these? Because remember, community caretaking doesn't require necessarily an emergency, and the Supreme Court says no. So community caretaking by itself does not justify home entry, because community caretaking stops or searches are not always for emergency purposes. Home entries generally, well, not just generally, they require urgency or emergency. And part of the confusion for years in the lower courts was sometimes many courts use the term community caretaking exception and emergency aid doctrine interchangeably. Those are two actually different things. The emergency aid doctrine, which does allow you to enter a home without a warrant, is based upon an emergency. Like we have probable cause to believe somebody inside this house needs immediate medical attention. Probable cause to believe if we don't go inside right now, someone's going to get hurt or killed. Like those are emergencies, and that is entering to render aid, not to investigate criminal activity necessarily. So it's similar to the community caretaking doctrine, but it's not the same thing. So the court said in Caniglia, no community caretaking, But remember, you do have the emergency aid doctrine, but you've got to have a reason to believe there's actually an emergency. So we have to have an objective reason to believe. And usually we're talking about probable cause or something similar to probable cause. And what we're doing, the entering the home and what we do inside the home has to be reasonably related to addressing the exigency, the emergency, or rendering the aid that we believe someone needs inside. So if we believe someone needs immediate medical attention, so we go inside of a home immediately, we shouldn't be in there opening drawers and rummaging through the house. We should be looking for people who need emergency medical attention and addressing that emergency then. That's what we mean by the conduct has to have a nexus to the emergency. I'm gonna skip over this video just for time's sake. But here we get a call, a 911 call. Neighbor says they hear yelling, items being thrown around. We get 45 minutes later. Both spouses are there. It's kind of an extended response time for a domestic, but okay. Everyone says the spouses say everybody's fine, nobody was injured. The police entered the home without consent. The court said this is unlawful because there was no exigency in this situation. It's been 45 minutes. They talked to both parties. Both parties said there wasn't no problem. Maybe there was 45 minutes ago, but as circumstances changed, the court said there was not enough reason to believe that someone inside needed immediate medical attention. State versus Reese. This is when officers go to a 911 hang up at a house. Husband opens the or he answers the door, but doesn't let officers in. He's got bloody knuckles, multiple cars in the driveway. He admits they're married. He's hostile and uncooperative. This case, the court said there was an exigency to go inside to make sure his wife or some other person inside the house does not need some kind of medical attention. And in this case, going back one slide here, this Reese case, the court mentioned the officer did a really good job of articulating his basis for believing there was an emergency inside the house. Here, we get these all the time. We get a call from a daughter out of state, says, my 80-year-old mother, it's been 4 days since I heard from her. She asked, can we do a welfare check? So we sent an officer out there, cars in the driveway, her car, several days of mail in the mailbox, no answer after we knock on the door. Can we enter the house without a warrant and without consent? Absolutely. This is a pretty good example of the emergency aid. The likelihood, that, well, I don't know, 4 days, she might still be alive in there, but we're going to go in that situation to make sure that someone doesn't need our assistance. And we've got a really good reason to believe that someone does need assistance in a situation like that. All right, so the takeaways from today. Well, we talked about community caretaking, different categories. It doesn't apply to homes, cars, people, as long as we can articulate to a reasonable suspicion standard, at least, that we believe someone needs assistance or a threat or some kind of that needs to be mitigated, we can detain for non-criminal investigative purposes. Hopefully you found this information useful. These hours seem to go by pretty quickly. Hopefully, but again, we talked about a lot of stuff, so hopefully there was one or two little tidbits in here at least that you guys found useful. Thanks, Karen. Appreciate it. So now let's do, first of all, we got to do our reviews. We started doing this recently. We've got QR codes specific. So I got one specifically for me. So, and I always say this, if you thought it was a good class, you leave me a review. What does your mother say? If you don't have anything nice to say, don't say anything at all. No, I don't mean that. I do I'm an adult. I can take constructive criticism. So if you have something, some feedback, we'd love to hear it about the class itself. Or about me. We'd greatly appreciate that.